and welcome to the CRIPS AI and Data for Lunch webinar. Hopefully you can all hear me. My name is Matthew Holman and I am a partner at CRIPS. And this is a lunchtime webinar for everyone who loves privacy law, tech, AI, and information rights. We are live on the first lunchtime of every Monday, bringing you the latest news and insights in this fast-moving area of the law. The very astute amongst you will notice that I am not live in the London studio. That is because of the train strikes, which were happening all of last week and into over the weekend. Although I heard over the weekend that the tube strike was cancelled. Either way, in the prep for this, you'd be amazed at how many people are involved in getting something like this running. And we've got guests and other things too. So we thought the best thing to do was to host it remotely. We will be back in the studio in London for the next webinar in May. Thank you very much for giving up 45 minutes of your day to come and hang out with me. In return for your giving up your time, we will take you through some fantastic updates, bring you up to speed on all the developments happening in this fast-moving area of the law. We will unpack the fascinating case of the TikTok ICO monetary penalty notice from April 23. Then we'll spend some time asking the difficult questions about how you make current data protection law fit with the modern model of generative AI and LLMs. Are those two things compatible? If so, how and why? And I'll be joined by two brilliant in-house lawyers, Alex Press and Lauren Turner from Domino's Pizza. We will end at 12:15 with three great things, where the three musketeers from the CRIPS tech, AI, and privacy team will come back with, come and update us with some fantastic things that they have found that AI has done since the last time we met. Without further ado, let me share my screen and we'll make a start. Hopefully you can see that. I'm just going to put a shout out to the CRIPS production team. Can you see my screen share?
Yep.
Fantastic. So the first update that I've got for you is all about the EU AI Act, which passed through the EU parliamentary process on the 13th of March. You would have to have been asleep under a rock with earbuds in and noise cancelling headphones on to have missed this monumental piece of AI law. It's the first attempt at regulating artificial intelligence anywhere in the world, and it was passed by an overwhelming majority, 523 MEPs, with 46 against and 49 abstentions. In other words, overwhelmingly approved. It's massive. It's over 800 pages long. I haven't even finished reading it yet. I would love to spend as much time as possible on the webinars taking you all through it. But to do that, we'd probably either have to all block a week out, come and hang out together and do nothing else for a week. Or, as is more likely, I will spend snippets of time throughout these webinars just picking off in bite-sized chunks the key things that the Act does throughout the course of this year so that we don't have to cancel the whole week. I think doing it that way will be useful, partly because the Act itself has a staggered implementation anyway. So throughout the course of 24 and into 2025, various parts of it will start to take effect. So expect more on that as the year progresses. The second thing is that the old standard contractual clauses are gone. Finito, never to be used again. If you are a data protection practitioner, lawyer, in-house counsel, interested academic, or anyone else, and you're doing anything with the old SCCs, you should have stopped on the 21st of March, 2024. If you're still using them, you must move to the new EU SCCs or the UK IDTA. Since the last time we met, the Experian versus the ICO appeal was heard in the upper tribunal. There'll be at least half of the people on this call with their head in their hands saying, surely he's not still talking about the Experian case. I am still talking about it because it's a fascinating case. It touches on virtually every area of data protection law that there is. It's also all the more interesting because Experian's monetary penalty notice was clearly laced with what felt like malice or some kind of resentment from the ICO, and then Experian absolutely blew them apart in the tribunal, where Anya Proops led the cross-examination against the ICO, and their witness was thoroughly beaten. That appeal was heard, and we are expecting to hear more on that as we go through the year. Hopefully a judgment will be provided later in the year. The next thing is the ICO launched the second phase, which is generative AI consultation. We're going to do a whole section on that later. So I'm not going to say very much more about it, but it started since the last time we met, and it is live until the end of this week. The next update is that there was a draft UK AI regulation bill published since the last time we met. That was published on the 26th of March. I'm sure a few of you will be sat there thinking, hang on a second, a draft UK AI regulation bill? Didn't he say there'll be no law in the last webinar? Well, I did say that. And that's because in the last webinar, we looked at the UK government's response to the white paper on AI regulation in the United Kingdom. And in that, the United Kingdom government said there will be no law for the foreseeable future. However, there is a audacious and brilliant proposal put forward by Lord Holmes of Richmond, who is a member of the House of Lords. It is a private member's bill, and he has introduced it to give Parliament some airtime on this most important topic. It's a fantastic bill. It covers various things. So it says, for example, that the UK should create an UK AI authority, which should coordinate other regulators. It should conduct regulatory gap analysis to enforce regulatory principles of AI. It should permit regulatory sandboxes, and perhaps most interestingly for us as a group, it will create the role of an AI responsible officer for any organization that develops, deploys, or uses AI. Think data protection officer, but for AI. Now, to be clear, this is the complete opposite direction to the United Kingdom government. And so we're in this political process right now. There is a draft bill. It will get parliamentary airtime. It probably won't get passed, but it is fascinating. It's the first attempt to regulate AI in the United Kingdom that we've ever seen. I'm also really pleased to announce that in the next webinar taking place on the 13th of May, Lord Holmes of Richmond has agreed to join me in the studio in London to do a 10-minute interview on his bill. So definitely not one to miss. I may have to wear a tie. The last thing in the updates is PPN 224. This is the kind of thing that sounds like it should be really dull, and it sounds like that because it probably is quite dull. It's the Procurement Policy Notice 224. It was published last week, and it's the UK government's guidance for the procurement of artificial intelligence by public bodies. Now, if you're interested in that field, it's absolutely something you must look at, must read. It's very, very important. But that is not the only reason to look at it, because it also includes guidance to civil servants on the use of generative AI. In essence, it's the government's own attempt at a generative AI user policy. So if you find yourself at work and someone says to you, we need to write a policy to do with Gen AI, we don't really know what we should and shouldn't be putting in, what do we do with it? Well, you could do a lot worse than looking at PPN 224 to see what the government has said to its own civil servants. It's a very interesting document, and one well worth studying if that's what's on your desk at the moment. I'm going to bring us out of the update. So that's all we've got. There's loads more we could update on, but we don't have the time. So come and tune in next time when we'll have all the updates that we've missed, plus anything else that's happened in this area of the law since from this webinar to the next one. I'm going to take us to the fascinating case of TikTok. Some brief facts for those of you who aren't aware. The ICO started an investigation into TikTok, and it took 26 months to complete. They started their investigation on the 25th of May 2018, which for all of you who are privacy geeks, you will never forget, that's the day the GDPR became effective. They completed the investigation in, I think it was July 2020, and then it took until April 23 for the ICO to finally issue the monetary penalty notice or fine. The ICO accused TikTok of breaching Article 8 of the GDPR. Article 8 is a prohibition on providing information society services to children under 13 without parental consent. So a very large chunk of this entire thing is about allowing minors and 13s onto the site, under 13s onto the site. The other accusation was that TikTok breached Articles 12 and 13 by failing to communicate processing activities to data subjects and for having significant gaps in the privacy policies. These breaches, there were several others as well, but we don't have time to put all of them in. These are the main two allegations, and they totaled to a fine of £12.7 million. Some of you might be thinking, how did they calculate that? Well, they calculated it like this. £6,750,000 was attributed to the breach of Article 8 and £3,950,000 to the breach of the privacy policy. What this shows us is just how seriously the ICO takes the use and abuse of children's data. It's virtually not quite double, but close to the number. The mathematicians amongst you will also be looking at that, saying those two numbers do not add up to 12.7 million. Well, you'd be right about that. They actually add up to 10.7 million. But this is one of the first cases of the ICO looking at a business's revenue and saying, on account of your successful financial performance, we will increase the fine. We will make it 12.7 million. There's actually this almost John Cleese-like hilarious line in the fine notice where they say, on account of the amount of money that you have made, we want to make this fine proportionate, effective, and dissuasive, so we're going to increase it by 2 million. The reason it's hilarious is because in that year, TikTok made 570 million as its total turnover, which would take the overall fine value to 2% of revenue, 2.3%. But it's even funnier because ByteDance, the global group of TikTok, made 35 billion US in the investigation period, which makes the total fine from the ICO 0.04% of global turnover. Now, clearly, a £12.7 million fine is bad news on any day for anyone, but in the context of those turnover figures, there are so many metaphors that I'm not sure which one to pick, but we'll go with drop in the ocean. Some other important facts before we move on are that TikTok's terms of use prohibited access by under 13. So the contractual terms to access the site specifically say that if you are under 13, you're not allowed on the platform. And during the same period, TikTok's users grew exponentially, hitting over 1 billion monthly users in 2020, which is a scale of growth truly remarkable. And one of the things that gets teased out of the monetary penalty notice is that even TikTok was surprised by its own speed of growth during this period, which may go some way to explaining how some of these issues occurred. Let's look at accusation 1, which is about the use of the data of children under 13. Now, the ICO estimated that up to 1.75 million children under 13 years old were using the TikTok platform during the investigation period. That is equivalent to 14% of all under 13s in the UK. Just pause for a second and think about that. 14% of all under 13s in the UK having a TikTok account in the investigation period. TikTok was not able to offer any estimate of the total number. So the ICO wrote to TikTok and said, listen, TikTok, we think that up to 1.75 million under 13-year-olds are on your platform. How many do you think are there? And TikTok answered with, we have no idea how many are there. We do not count that number. We can only tell you how many people over 13 are on the platform. Section 9 of the DPA sets the threshold for consent at 13. So if you're under 13 and you're providing any kind of internet service or platform, you must get parental consent for anyone under that age. And to be clear, absolutely everyone thinks that under 13-year-olds should not be on the TikTok platform. The ICO think that. The law is very clear about that without parental consent. TikTok itself is of that opinion because it's explicitly prohibited by the terms of use. You have to be over 13 to access the platform. Even so, the ICO was of the opinion up to 1.75 million under 13-year-olds were there, and essentially there because they were gaming the system. So the first allegation that the ICO made in this section is that you need to have consent for anyone under 13. That consent has to come from the parents, and we haven't seen any evidence to support the idea that you have that consent. In response, TikTok argued that it didn't need consent because its lawful basis for processing the personal data of anyone that was potentially underage would have been the performance of the contracts. The second allegation was TikTok didn't do enough to remove under 13s from its site. Well, TikTok argued that the steps it had taken to remove children and under 13s from the platform were reasonable in all the circumstances. Now, the ICO considered this at length. There's a lot of content which we won't digest, but in essence, they gave both arguments very short shrift. The ICO said in response to the lawful basis of the performance of a contract point that children under 13 do not have capacity to enter into a contract. Even if they did, it is not a contract that would be enforceable at the instance of TikTok. In response to allegation 2, that TikTok had made reasonable steps to remove under 13s, the ICO said that it had seen no evidence that reasonable efforts had been taken to verify consent in the first place, that there was nothing stopping children from making a false declaration of age and thus being able to access the site and create an account, and the TikTok steps in all the circumstances were not satisfactory to remove under 13s. It also acknowledged that children under 13 on the site were exposed to harmful content, including videos of animal abuse, hypersexualized content, grooming, cyberbullying, white supremacy, and staged kidnapping. All of this can be found on pages 17 to 18 of the decision. All of this is exacerbated by TikTok whistleblowers who were reported as having raised flags that under 13s were being routinely admitted to the site and shown harmful content. In the interest of trying to be independent, TikTok's response on this is that they publicly stated that they are deeply committed to ensuring that TikTok is a safe, positive environment for people under the age of 18. It adds that for it to be safe, this starts by being old enough to use the platform. You must be 13 or older to have an account. However, The Guardian in December 23 reported that it had seen evidence that large numbers of under 13-year-olds were still accessing the site. So there is a big moral quandary for all of us here about under 13s being admitted to a platform that they are too young to be on. Now, I'm going to stop the screen share there for a second, because all of this is getting my creative juices flowing and making me think that, well, maybe we should be conducting some kind of, I don't know, a live experiment. To do that, let me call into this virtual studio room Alice Hunter and Louis Marr of Musketeers fame. Thank you very much for agreeing to participate. Alice, I've got a challenge for you.
Yes, Matt.
I would love it if you could try to create a TikTok account now while we're live on air. I'm going to keep doing the rest of the presentations on the other things that TikTok was accused of. And I'd like you to see if you can create a TikTok account, but input your date of birth as being under 13 and see what happens. See if the age gating prevents you from accessing the site.
Can do that.
Louis Marr.
Hello there.
I would love to give you a challenge of doing the same thing, trying to create a TikTok account, but this time input your details as though you were over 13. and see what happens in the age gating process. See if if TikTok makes any attempt to make sure that you are actually over 13 and permitted to get onto the platform. Sound like a challenge?
It does. I relish the chance to be dishonest.
This is purely an experiment. No dishonesty is taking place for the purposes of the SRA. Right. Thank you very much. I will look back here in about 5 minutes' time when I've finished the slides on accusation 2, and we'll see how you got on. Right. Let's carry on. Where were we? Love an experiment. What's going to happen? True to form, it will probably all go horribly wrong, but let's find out. So, hopefully you can all still see my screen. Accusation 2 is not about the use of children's data at all. It's actually about privacy notices. Now, prepare to have your mind blown if you are in the world of scrutinizing privacy notices, drafting privacy content, advising on terms, or anything like that. There are a lot of things that are very commonplace that the ICO has said are not okay. The first one is Article 13.1c. So Article 13.1c basically says that a privacy notice must contain the purpose of the processing of data as well as the legal basis for processing it. We don't have time to look at all the privacy wording that TikTok had. There was loads and loads of content. If at some point in the future we get together and do a face-to-face session, a face-to-face seminar, which will probably be at our London office, and we're talking about doing that later in the year for half a day or something like that, I would love to do a session with you all on this, because it's basically like the ICO taking a privacy notice and a ruler and a red pen and just going through it and absolutely dissecting it apart. The privacy note, this bit of the privacy policy for TikTok said, we will use the information we collect about you to perform our contract with you as follows. And then it lists a bunch of fairly standard things like notifying you about changes, enforcing terms, administering the platform, all fairly standard. The ICO's response was this. It says, TikTok made references to general categories of processing, but the categories were not cited in a way that would allow data subjects to recognize them as a distinct lawful basis. There is not a clear link between 1, specific processing activities, 2, the category of personal data used, and 3, the lawful bases relied on. Now, just pause and look back at the TikTok privacy wording. The underlying section clearly identifies a lawful basis. It may arguably be a wrong lawful basis, the performance of a contract, but it is nonetheless a lawful basis, and it's connected to the specific processing activities. What this section seems to suggest is that unless there is a clear line-by-line table, even more succinct than the standard PLC template version, then if there isn't that, with a column that's saying this is the processing activity, another column saying category of personal data for that activity, and yet another column saying what the lawful basis is for the processing activity, anything short of that would not be viable. TikTok argued that this was excessive. They said that having to explain terms such as platform administration or support or security would make the whole privacy policy lengthy and inaccessible. That, I think, is a point that's got some merit, because drafting privacy policies is a bit of an art. Article 12 and Article 13 seem to live in tension. Article 12 of the GDPR says your privacy policy needs to be short and snappy, and you've got to communicate clearly in a way that the average user will understand. But Article 13 then has this long list of up to 14 things that you need to contain. Striking a balance of what to say in an organization as large as TikTok is pretty difficult. The next example, just to really help get this point home, is in Article 13.1e that says that if personal data is being shared, then you must identify the recipients or categories of recipients that you're sharing it with. TikTok's privacy policy said this: we share your data with third-party service providers who help us deliver the platform, including business partners, other group companies, Facebook, Twitter, Instagram, Google, etc. And the ICO said that in all three privacy policies, we'll come back to that, TikTok provided a high-level description. However, the ICO's view is that TikTok was required to provide either all of the name recipients in order to comply with Article 31E, or at least sufficient detail on the categories of recipients so that data subjects were able to know, pause, exactly who held their personal data. Now, let's think about that last bit again. The emphasis on the final words, exactly who held their personal data. That, I would suggest, is way more than what Article 31E actually requires. The guidance on this is not particularly clear either, but the standard the ICO seem to expect of our privacy notices when we are listing where we share data is that every possible place that it goes to is made clear to data subjects. Again, TikTok argued this was unreasonable, that it was going to make privacy notices unintelligible. The ICO gave it short shrift. Let's look at one more, because if you've got this far in the process and you think, oh, this doesn't look great, but I feel like we're okay, like I feel like our notices are fine, let me show you this one, which is going to finally torpedo that feeling for you. Article 13(1)(f), as we all know, says a privacy notice must identify transfers of personal data to a third country. Here is the standard wording from the TikTok privacy policy. I won't read it to you because it is almost verbatim the PLC wording for transfers outside of the UK or EEA. It says we rely on standard contractual clauses. If you want to find out more, see those here. The ICO's response was that all three TikTok privacy policies failed to identify all of the third countries or the organizations to which data was transferred or the use of suitable safeguards. And then the final killer quote, referring to SCCs alone in the privacy policy does not provide the data subject with the requisite information. Now, all of this suggests that Article 13(1)(f), to comply with that, you need to list every country that your processes are active in. And just saying we rely on SCCs doesn't mean anything at all. Now, I had about 15 minutes to kill before we came on air. And of course, I get the list of attendees beforehand. And I was just checking out some of your websites to see if you had the same wording that all of us have, which is the wording that TikTok has here, more or less. And every privacy policy that I looked at contained it. This is completely standard wording. The ICO are saying it's completely wrong to do it this way. But what they aren't doing is providing any explanation as to actually how this should be done. I've said a couple of times TikTok had three policies. Interestingly, I'm not going to talk about this for too long, but they updated their privacy notice 3 times during the process. And the ICO essentially held that against them and said that every time you're updating your privacy notice, what you're doing is showing us that there are flaws in your privacy notice. TikTok said that it was wrong to do that. The ICO said, well, we don't think so in this context. Now I'm going to stop the share there because we're slightly over time, and I'm going to invite Alice back into the virtual studio. Alice, you were sent up on an experiment to see if you could create a TikTok account with someone under the age of 13. How did you get on?
Yep. So for the purposes of this experiment, today is my 12th birthday. And I attempted to make an account on TikTok. But the first question I was asked was, what was my birthday? So step 1, I've gone to put that in. And the error message that's come up said, sorry, looks like you're not eligible for TikTok, but thanks for checking us out. So
Excellent.
I can't get any further.
So the age gating worked because you were an honest metaphorical 12-year-old and you told the truth and TikTok declined you. Let's invite Louis back into our virtual studio. You were sent off with the task of seeing what age gating protections were in place. What happened?
So I downloaded the app. I had an email address ready. I got sent a code. I entered my age as being 14, and I was duly allowed onto the app to create an account with a nickname, which I entered as I am under 13, just to raise that flag. And I was watching videos of cats and monkeys and whatever within seconds. And I think the whole process took about 90 seconds.
Right.
If you say you're over 13, they will take your word for it.
So there's no additional security steps to make sure that you are the age you're saying you are.
Nothing that requires anything of the from the user. So unless there's some background process that we don't know about.
Okay.
But nothing required of me to verify age.
So you could have been a dishonest 12-year-old saying that you were 13 and got onto the platform.
Yeah.
So there you have it, viewers. The TikTok age gating still, as of 12 o'clock on the 8th of April, is at least appearing to let people onto the platform without verifying their age. Thank you very much for that experiment. I hope you found this session useful. We could do hours on this case because it's such a great case, but we're going to stop. We've had a couple of questions in the Q&A. One of them is, are there any gift cards for the Experian compensation? Which is a great question. We should definitely recommend that. And another question on the privacy notices from the TikTok case. Do other European regulators take such a strict interpretation of the GDPR with privacy notices? Is the UK an outlier here? The UK actually isn't an outlier here, and the approach from European regulators to privacy notices is probably more strict. One of the most interesting cases on this is CNIL and Google from 2018. CNIL, which is the French regulator, fined Google 50 million euro because its privacy notices were confusing and opaque and unclear. That case has the brilliant sentence in it somewhere that says, Google, we don't even think you know all the things you're doing with all the data you have. You have privacy policies that were inconsistent and over-layering each other. So I would say that the ICO's approach is probably consistent with the European continent. Thank you for those questions. Let's go to our third session of the day, which is all about how do you make artificial intelligence, generative artificial intelligence, comply with data protection law. I'm going to share my screen very quickly. Hopefully you can see that we're going to talk about how do you make generative AI comply with the law. The ICO launched a consultation in January 2024. First consultation asked this question: what is the right lawful basis for generative AI? Why? Well, in order to collect and process personal data, generative AI developers and users need to have a lawful basis. And the ICO's view was the right basis was probably legitimate interest. That consultation ran from January 24 to March 24. The CRIPS team produced a consultation response, all of which you can find online. There is now a second live consultation. It asks the question about whether Gen AI is compatible with the purpose limitation. Why? Well, in order to comply with the principles, you need to have an explicit, legitimate, specified purpose. Without it, you would be breaching UK GDPR. That consultation is live right now and runs until Friday, the 12th of April, 2024. Now, I'm going to stop the screen share there. I'm going to invite into our virtual studio Alex Press and Lauren Turner of Domino's Pizza. Welcome to you both. Alex is Senior Legal Counsel, Data Protection Officer at Domino's Pizza. Lauren, Legal Counsel at Domino's Pizza, both specialists in all things privacy law and AI, and both active participants in the various AI consultations. Definitely the right people to fire some questions at. Alex, I'm going to fire some questions at you. Before we start, here's a question. If you were stuck on a desert island, what album would you take with you?
I would take Discovery by Daft Punk.
Excellent. Cats or dogs?
Definitely dogs.
Netflix, Amazon Prime, or Disney Plus?
I will go Disney Plus because it's best for the kids.
And I'm going to hit you with a question straight away, which is, you've worked on a few consultations. This one is very different in its format and layout. The content is very short. Is the format better than other consultations, or is it worse? And why? Depending on your answer, why?
So I think there's pros and cons. I think you're right. It's definitely much shorter and punchier, and the timeframes for responding are a lot shorter than they have been on other consultations that we've worked on. I think there's a lack of content in some areas as a result of that shortness. I think Some of the questions are hard to sort of decipher based on what you're being consulted on. And I think it's quite hard to sort of work out exactly what the ICO are asking for based on their consultation document, as opposed to, say, the government white paper consultation, which was extremely detailed, very thorough, lots of examples that are somewhat lacking in the ICO's consultations. However, on the plus side, I would say it's been quite good to be able to focus on specific areas. So, like I said, purpose limitation for this specific consultation we're working on at the moment, it's been really good to really delve into the detail and unpick that specificity that comes from having a slightly shorter consultation.
Lauren, welcome.
Morning.
If you were going to be marooned on a paradise island, what book would you want to have with you?
I guess some sort of book that would help me survive to get off said island.
It's a very practical answer. Damn it, you've got me. What's the nicest pizza you've ever had?
Without giving any spoilers away, we were trialing a nice pizza in the office recently, so maybe one to come, but I can't give any further details.
The Domino's menu that's on its way. Pepsi or Coke?
Coke.
Easy. The first ICO consultation, it talked about how the right lawful basis in the ICO's view was legitimate interest. What was your view? As soon as you heard that, did you think, yeah, that sounds right? Or was your gut feeling, well, actually, I'm not sure about that?
My gut feeling was saying I wasn't sure. I wasn't sure how it could fit into the current test for legitimate interests. And reading the fairly short consultation the ICO produced, it seemed like, and the conclusion we came to as a group, is that they had no other option. And none of the other lawful bases seemed to work. So it was a case of trying to make this one work.
Did it feel a bit square peg round hole?
Yeah, definitely. And I think that was the overall conclusion we came to when discussing it. It was just, we don't understand how this can fit.
Question to both of you. The consultation, that first consultation said, the key question is this: if you don't know what your model is going to be used for, how can you ensure its downstream use will respect data protection and people's rights and freedoms? So do you think that Gen AI can cause harms? Do you think that the processing of data is within reasonable expectations? Alex, do you want to go first?
Sure. So yeah, I think there's no doubt that there's great societal benefits to AI. We're already seeing them in a load of industries, but I also think there's equally, no doubt that there is a significant risk of harm from AI. I think there's a whole load of cases where we've seen issues occurring as people sort of grapple with this. I won't say new technology, it's been around for a while, but I think it's really coming to the forefront now, isn't it? But we've spoken previously that this is an election year. There's a lot of big elections taking place in 2024, and I think the risk of deepfakes and the harm that can come from there, from a democratic point of view, is very real. And then deepfakes again in the pornography industry. Taylor Swift has had issues earlier this year. The music industry are up in arms at the moment around the whole issue of copyright and what can happen and how artists can be protected. And then saw recently, I think you even shared an article in relation to potential use of AI in the Gaza war. The Guardian were reporting that AI has potentially been used to identify people with terrorist links. So I think from a harm point of view, there's nothing more harmful than potentially having AI identify you and potentially say that you should be got rid of, shall we say.
If that doesn't fail a risk assessment.
Well, yeah, exactly. Indeed. And then just very briefly on reasonable expectations, I think it depends who you speak to. I think the majority of people on this webinar are probably relatively au fait with Gen AI and understand that there might be more processing taking place than say the general public. And I think there's work to be done for the public at large in terms of education and coverage and just general transparency to make people more aware of what's going on.
Yeah, just to add to that, I think I agree that generally that there is harm that could be associated with AI. I think that's a given. And just with how the models are trained, they're trained from data which is web scraped off the internet, and that internet data could be around for years and now be inaccurate or out of date, include errors. So I think it's just it's a natural given that it could cause harm.
Inclined to agree. Let's move on to the second consultation, which is the purpose limitation. Lauren, do you think it's possible to know at the start of the Gen AI data collection journey what the purpose of processing will be at the end of the journey? Or do you think that actually that is just too obscure a concept for the purpose limitation?
I think, given a classic lawyer response, it is possible. However, I think in reality, I think the likelihood of that being the case is pretty slim. I think the whole nature of Gen AI is that it has the ability to grow and develop as the model develops. So I think it would be hard to assume that the purpose will stay the same throughout the process with different developers and applications using the model.
I'm inclined to agree, especially because the whole point is to create data for the very first time. Last question, Alex. The consultation tackles the purpose limitation and suggests the ICO thinks that the purpose test may actually be passed. That's sort of implicit in the fairly scruffy consultation we talked about. What's your gut feeling to that? Do you think actually maybe it can be passed, or are you sort of veering towards where Lauren was and thinking, no, it's just no way?
I think in a way, it's similar to the last consultation. I think you're going to end up in a situation where there's sort of the theory, the academic theory versus the in practice reality of what happens. And I think quite often those two concepts will butt heads. And I think in theory, academically, it is possible. And I can certainly see where the ICO are coming from, and suggesting that actually if X, Y, Z take place, then yes, in theory, it should be permissible for it to be passed. But I just think in practice, it's going to be very, very difficult for organizations to demonstrate exactly how they map that out and get things done. And I think ultimately, as is the case with all data protection law, ultimately it will be a case for businesses, ourselves included, to interpret the legislation and the guidance and whatever comes forward and decide where we're comfortable. And then ultimately it'll be for the regulator to determine whether that's okay or not. Exactly as you've just said with TikTok. Everybody on this call has implemented a privacy policy that sits in line with how TikTok did things. And now they've been hauled over the hot coals and said, no, we don't agree. We think that's wrong. So that's kind of how things work and develop in practice, isn't it? Everyone picks a view that they think they're comfortable with, and it's ultimately for the regulator to come in and say yay or nay.
Indeed. Thank you both very much for jumping onto this webinar and giving us your thoughts, Alex Press and Lauren Turner from Domino's. I'm sure we'll see you again on a webinar soon.
Thanks very much.
Thank you.
We're almost out of time, but we try to end every session with 3 great things, because we don't just love talking about the law and the policy and the guidance. We also love talking about the tech itself. We are unashamed tech nerds. And so I'd like to invite into the virtual studio for the very closing moments of this webinar, Louis Ma, Alice Hunter, and Jazz Kaur, who are going to share with us 3 great things that they have found that AI has been doing since the last time we met. Jazz, I'm going to come to you first.
So last week, a New York-based startup called Hume launched the first ever conversational AI with emotional intelligence. So essentially, this empathic voice interface, or EV, can detect and interpret human emotional expressions and generate empathic responses.
Wow. So this is AI that responds with things like, oh no, you must feel bad, etc.
Yeah, so the API was basically trained on millions of human interactions, and it works by measuring aspects such as tone, pace, pauses, size, rhythm, and various other nuanced vocal modulations, which guide human language and speech. And then EV assigns emotions in varying percentages to the questions posed and responds in a human-like way with the appropriate tone and expression.
Wow, amazing. And miles past the Turing test at this point. That's incredible. Alice Hunter, I'll come to you, our honest 12-year-old from earlier. what amazing things have you seen AI doing in the last 4 weeks?
So OpenAI have recently developed a new humanoid robot in partnership with a company called Figure AI. That's a new startup that's already been valued at $2.6 billion.
Wow.
So they've made this robot, and it looks and moves like a human, and it can have full conversations with people. So it's got speech-to-speech capability through the OpenAI system, and it's probably by far some of the most advanced robotics we've seen. It's very realistic. So although there's a slight delay in the speech, it's even programmed to say and ah and hesitate almost like a human. So realistic, I would half expect it to take a coffee break. But I think the intention is that it's going to be used in a warehouse setting, so it can help with the sort of heavy lifting that humans need more assistance with. So remains to be seen how that goes.
Love that. Last but not least, Louis Ma, our cheeky 13-year-old from earlier. What amazing things have you seen AI doing in the last 4 weeks?
So I spoke about space last time. I've tried to be much more down to earth this time, so to speak. And I stuck to the world of farming, where researchers in the US are working to improve what they call precision ag, or precision agriculture technologies. And a farmer can now point their smartphone at a plant, pick out a bug, and snap the photo of the pest, and let an AI-driven program decide whether that's a cause for concern, identify the species of the bug, etc. And that's part of a whole range of existing technologies that are sort of being augmented by AI to improve the efficiency in agriculture and make sure that the human effort is much more precise and targeted than it otherwise would be.
Amazing. That is the end of our webinar. We're ever so slightly over, so I'm going to wrap us up here. I hope you've enjoyed yourselves. Thank you to all of our wonderful guests. Thank you to Alex Press and Lauren Turner from Domino's Pizza. Thank you to Louis and Alice for showing us that TikTok still has a way to go on age gating, and to Louis, Alice and Jazz for 3 great things. We will be back live at lunchtime on the first working Monday of May, which is Monday the 12th. Monday the 13th of May 2024. The first Monday, of course, is a spring bank holiday. We will start our series on the EU AI Act, and I will be interviewing Lord Holmes of Richmond. He'll be live in the studio in London, taking your questions on the UK AI regulation. All of that, plus more updates and 3 great things. Please join us next time. Until then, have a fantastic rest of your month. Thanks very much. Goodbye.